Welcome to Legally Agile with Chris Werner.
Welcome to Legally Agile, the podcast for founders and executives of high-growth companies who want legal strategy that keeps up with the business. I'm your host, Evan Mack, and today I'm here with Chris Werner, founder of Vidar Law. Chris helps high-growth businesses navigate risk, seize opportunities, and stay legally agile without slowing momentum. In this episode, we're talking about every founder's least favorite topic, serious disputes. We'll walk through what really happens when the first scary letter arrives, the mistakes to avoid in the first 72 hours, and how to approach disputes with the business first mindset. Chris, welcome, sir.
Thank you. Yeah, you're absolutely right. This is a scary topic for a lot of people, but one I really like talking about because I think it's important.
Amazing. Chris, when a dispute is starting to form, what are the first signs a founder usually sees, and what kind of disputes do they usually involve, and whether it's a non-payment, IP, founder issues, employees, or regulators?
Yeah. Let me step back and just say, for founders, and especially for first time or maybe even second time founders, I want to preface this by saying you're going to eventually get into a dispute, and the more successful your company becomes, the more likely you're going to have a dispute. So there's a lot of different varieties that this can appear in. It can appear in investor disputes, co-founder disputes, employee disputes, intellectual property disputes. There's a whole variety of things that could come up. But the more successful your company is, the more likely one or more of these things is going to come up eventually. And kind of having a game plan and at least rehearsing this in your mind allows you to react in a way that is productive and not in a way that could damage or hurt your company.
But when the other side's lawyer sends a letter or makes contact, what is typically happening behind the scenes on their end?
Yeah. So again, like I said, the more successful you are, the more likely this is going to happen. So usually, you'll find out about a dispute because you get a letter from a lawyer, right? And they're representing either an employee or an investor, someone like that. And what's happening behind the scenes is the other person, whoever that is not happy with something you've done, right? Whether it's real or perceived, or whether it's tactical on their part. They are trying to get a reaction from you. The other lawyer is going to send a letter to let you know that there's a dispute. And what they are trying to do is establish a starting point for this dispute. And a lot of things get triggered on that starting point, but they are trying to establish a starting point. And they may also be trying to get you to react on your own right away. Because often, as lawyers, if we can get an individual to react, we often get things that we can use later on in a court case.
For founders, these moments often feel personal. Why does a dispute trigger that reaction? Why is that reaction important to understand?
Yeah, I mean, so I've worked with a lot of founders, and it always feels personal to them. It always feels like a personal attack because the company, especially if you're a founder, is almost like a child, right? You've started this thing from nothing, you've grown this, you've poured your blood, sweat, and tears into this, and now it's an attack. It feels like an attack. And it feels like literally a physical attack. And most people I know will have a physical reaction. Their stomach will get upset, their heart rate will go up, they'll see these things and they'll want to react, and it's a natural human instinct to react. And one of the things I like to tell people is lawyers, we operate in a way that is not natural human behavior, right? Court cases, litigation, those types of things. This isn't no natural way to interact. It's not a natural way to communicate, but it's a process. And so it's perfectly natural for founders to feel upset, to feel attacked personally. But what I always want to caution is you can't react in that, sort of visceral, emotional way when you first find out that there's a dispute going on.
In the first 24 to 72 hours, what are the common missteps that tend to make a dispute harder to manage?
Yeah, so The first, couple of hours, couple of days, I don't think this is new wisdom, but you can't win your dispute in those first, 72 hours, but you could lose it with how you react. So it's really, really important that your first move is not to call the other side, not to try to resolve this yourself. That your first move is to contact your attorney, and just just like the other side is trying to establish a starting line, right? You also want to establish that starting line. And so as a founder, if you find out that there's a dispute, your first move is to call your attorney. You establish that attorney-client relationship, which establishes a privilege on those communications. Then you can vent to your attorney, right? If my client calls me and wants to vent about how unfair all of this is, and the other side is lying and everything else, great. You can tell me all of that, and it's all privileged and confidential. But you cannot tell that to the other side. You cannot tell that to their attorney. It will come back to bite you in a very, very negative way.
But Chris, is there a situation you've seen, without naming details, where an early emotional response made the company's position more difficult?
Yeah, so this happens. Unfortunately, this happens a lot, and um, so especially with entrepreneurs, and the people that I work with a lot, these people are very smart individuals. A lot of them are smarter than me, and I have no problem admitting that. They're very intelligent, but they're driven and they are used to solving problems, right? If you're going to start up a tech company in an emerging industry, you know how to solve problems. You know how to work around things. You know how to get things done. A legal dispute comes up, and a lot of founders think, okay, I can solve this. So I have seen situations where, a founder has been notified of a dispute, and their first reaction is to call the person on the other side and say, hey, let's work this out. That's bad enough, but the worst case is getting on the keyboard and sending an email.
Hmm.
It I have had an email be sent sort of immediately before I was involved, and that email was used against the company, and it was probably used unfairly, and it was probably taken out of context, and it was not what the person intended. But unfortunately, um, no matter how smart these founders are, lawyers are tricky, right? And we know how to take those words, and um, I don't have to prove that you meant something. All I have to do is convince a judge or a jury that you might have meant this other thing by that. And so um, this is why I say you can't win that case in the first 72 hours. You can't win based on your reaction or talking your way out of it, but you can certainly lose or hurt yourself in those first 72 hours.
When you begin working, through a dispute, how do you help the company identify the real business objective, whether it's protecting a relationship, managing precedent, controlling costs, or even something else, Chris?
Yeah, so, you know, uh, litigation is a little different than business law, in that each dispute has its own different flavor. I don't think any two pieces of litigation, and I've been doing this for more than 20 years, I don't think any two pieces of litigation are the same. But what we can do is start to develop a roadmap based on what's going on. So the first thing we want to do is establish kind of what's happened. What have we received from the other side, either the individual who is saying there's a dispute or their attorney, more often. Let's figure that out. Let's figure out what really was going on. Um, and then we want to make sure that we are preserving things. So, here's another example of early action that can really hurt you. Um, you get a letter from an attorney and they claim there's a dispute, and you realize, hey, maybe there's an email or a piece of paper that could be taken out of context, right? And so, fortunately, I don't see this very often, but I have seen it where the person thinks, let's just delete this. Let's get rid of this, right? That's the worst possible thing you can do. And so what I like to do very early is establish that everything will be preserved. All documents, all communications, you got to save everything. I tell clients all the time, if there's a bad document, a bad fact, a bad piece of information, and I know about it, I can deal with it.
Hmm.
If you hide it from me, or if it's deleted, even worse, I can't fix that problem then. And, that could also lose your case from the very beginning. And so we like to establish sort of a timeline of events. We like to establish document control. We like to make sure that we gather as much information as possible, and then we have a considered response. You know, the other thing, especially with a lot of the technology that companies are using these days, sometimes there's automatic deletions that go on, right? It's not even intentional deletion. So the other thing we want to do is make sure we pause any of that, right? If you have any system that is automatically deleting documents, emails, anything that are older than, a certain amount of time, all that has to be paused. We can restart it later, but we have to pause it and evaluate. So establishing a timeline, evaluating the facts, and making sure that we're preserving and keeping everything in terms of documents and information is extremely important in that first 72 hours or the first week after there's a dispute.
Companies often assume disputes automatically mean litigation. Chris, what do you think about the different tools available, like negotiation or mediation, when each other, when is each the right fit?
Yeah, so, my default on a lot of these is part of that initial analysis is to figure out what's really going on the other side. I've had situations where really what happened was a miscommunication, right? And um, it really was something where there needed to be a phone call and a discussion, and we've resolved things before it really went very much further. So it's possible to do that within a week. Well, I say that, this goes back to my earlier point, right? As the client, you shouldn't be having that phone call, even if you're sure this is a mistake or a miscommunication. You need to talk to me, and I will have that phone call, because you may be right, but you may be wrong. But I always think early resolution is the best. Litigation is a last resort. Now, mediation and arbitration, you mentioned those two things. They both have their place. Mediation generally is a non-binding way to get a neutral person to come and look at the dispute and give an opinion to everybody. A good mediator will try to get both sides to some sort of compromise, right? And they will push both sides and tell both sides the weaknesses of their position. A mediator's job is not to determine right or wrong. A mediator's job is to see if there can be a settlement, and it's usually in the middle, and usually nobody gets everything that they want, and that's what mediation is. Arbitration is slightly different. People who aren't lawyers tend to think mediation and arbitration are the same thing. Arbitration is a much more formal process. It's essentially, it can be just as expensive as litigation, and it's a formal process like litigation, where you have a finder of fact, the arbitrator, who will decide who's right and wrong and give a ruling. Arbitration can be binding or non-binding. The parties would have to agree to make it binding. Arbitration is not necessarily less expensive than litigation. The advantage of arbitration, and this is especially true for startups, is arbitration is private. Litigation is public. If a case is filed in court, that's a public record.
Hmm.
For a founder or a company, that means that future investors can go and find those records and find them pretty easily. That may be a problem if you are close to a fundraising round or an exit or something like that. You may not want that public. So arbitration where you're doing it in private, that could be a big advantage, but it's not necessarily going to be cheaper for you.
How do boards or investors typically view these disputes, and what guidance do you give companies about communication and optics during these situations?
Yeah, so depending on what stage you're in, there will have to be disclosures along the way as to what's happening. It could be to your investors, it could be, it's almost certainly to your board of directors. And if you're a public company, there are certain rules that tell you when you have to disclose things publicly or not. I would say the more sophisticated your investors and advisors are, the more they will understand these types of disputes. But you need to be ready to answer the questions. And again, this all goes back to what your initial response to the dispute is. My job often is helping the founder figure out, okay, what really did happen here? What are we going to say and how are we going to resolve this? A lot of times the resolution is, well, let's pay and resolve this, but let's make sure we paper this over that this isn't going to come back at some later time. So if it's private, confidential, and you get full releases, that could be the best course, even if you've done nothing wrong. And then together, I will help you decide, okay, how do we want to disclose this to the board? How do we want to disclose this to investors? Do we need to do that? So those are sort of fluid things that move as you go in the dispute process.
And finally, when founders need a clear plan for the first 72 hours, what steps help stabilize the situation and reduce unnecessary risk? And what are a few clear, do nots they should keep in mind, Chris?
Yeah, so I think we've touched on some of it, but obviously, my first the first step is to get a hold of your lawyer. If you're not already working with one, you need to find one right away. You should not be having a response on your own. If you're a founder, you should not try to respond on your own. You need to contact a lawyer. The other thing immediately to do is make sure that all of your documents, all of your information is preserved. Sort of you want to freeze everything in place where it was when you got notification of the dispute, whether it was by letter or phone call or some other way. And then you want to take a deep breath. There's gonna be emotions, so allow yourself to feel those emotions, whatever they are. And I know that's kind of touchy feely for a lawyer to say. Allow yourself to feel that, but don't take any action based on those emotions. It's natural to have them, but it's a huge mistake to act on them. And then allow your lawyer to come in, um, be as honest as you can, even if you made a mistake. You've got to let your attorney know, hey, I think this person who's their lawyer contacted me and they may be right about some of this stuff. We may have made this mistake. You have to tell your lawyer that, right? And I don't want you to tell anybody else that. But you need to tell your lawyer so they can understand exactly what happened. The more I understand, the better able I am to address the dispute and advise you on how best to go about resolving it. And every dispute can be resolved, right? Like, there's very few things in a business context that can't be resolved. Usually it's money. It may be something else, but at the end of the day, we can fix the problem. But what you don't want to do is make the problem worse. You don't want to exacerbate it. You don't want to cut your lawyer out of the loop of information. And if you do that, you're going to have a better outcome. I'm not going to say that every outcome um, is going to be 100% satisfactory to you, but I can guarantee you're going to have a better outcome if you sort of follow that plan and don't react emotionally.
Awesome. Chris, thank you so much.
Hey, thanks a lot.
All right, guys. Thanks for listening to Legally Agile with Chris Werner. If today's conversation sparked questions about your own company, whether it's legal foundations, disputes, or getting a deal ready, you can find more resources at vidarlaw.com/podcast. You also find simple 72-hour dispute response checklist you can share with your leadership team. If you found this episode helpful, please follow the show and share it with another founder or executive who benefit. We'll see you in the next episode. Thank you so much.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.